school zone modification motion. And what Mr. Hardin is asking this court to do is to convert his improperly filed appeal to a petition for a writ of certiorari, and then grant the writ of certiorari, and ultimately reverse the illegal or arbitrary order of the lower court. It's been discussed in several of these cases. The one that is cited the most commonly is Bobo, but there is no right to appeal these rulings in these school zone modification motions. However, under the right circumstances, someone can petition for certiorari, and that was discussed in the recent case of State versus Eric Patton. And under certiorari, even though you don't have an appeal, you do have the right to get some sort of more limited review. What we had here was a defendant, a pro se defendant, who filed a notice of appeal. However, there is case law, I think I cited 2 or 3 different cases saying that this court can transform an improperly filed notice of appeal to a writ of certiorari. And the standard for doing that has been cited as either good cause or the interests of justice. Good cause was cited in the case of State versus Phillips, and then State versus Leaf called it the interests of justice. And then there was also the case of State versus Jeffrey Zarnick, I think also called it the interests of justice, and transformed an improper appeal to a writ of certiorari. Here the good cause is that we had a pro se inmate, pro se prison inmate, or at least he was effectively pro se because his lawyer withdrew at the end of the hearing, and he didn't get another one until about a month later. So he was pro se. This was a new procedure. It wasn't real clear to probably a lot of people, but especially people who aren't even lawyers, what the appellate procedure was if you wanted to try to get further review of this type of case. And so he was pro se, it was new, and the judge specifically told him that he could appeal. The judge said, now, this is all new, so I'm going to let you appeal that decision if you'd like. And then Mr. Hardin, I think it was 27 days later, his notice of appeal wound up arriving at the clerk's office that he had mailed. And then around that same time, apparently the court appointed him an appellate lawyer who also filed a notice of appeal. I don't remember who that was, but it was a different lawyer than myself.
Was the trial court's ruling saying you've got a right to appeal, was that before Bobo came out as published law?
I think it was after, but honestly, I don't know off the top of my head. I think this happened in, no, I can't really even say. I don't know. But in any event, due to that confusion, that's why the appeal was improperly filed, but we are asking to transform it for good cause. And then I've seen another one of these cases that came out about 2 months ago, and I was trying to look it up while I was waiting here. I can't remember the name of it, but in that case, the defendant asked to transform his petition for a writ of certiorari, but he waited until the reply brief to do it, and ultimately the court shut him down on that basis, just saying, issues where you wait until your reply brief to raise them are waived. And I submit that even that, being that strict, was a little bit dubious, because in Leaf and in Zarnick, I don't think anyone ever asked to transform it to a writ of certiorari in either of those cases, and yet the court did it, basically sua sponte. But in any event, we've done better than that other defendant from a couple months ago, because we did raise this in our opening brief, and so it does seem appropriate to let us do it here. Once we get past the issue of the procedural error, the writ of certiorari should issue and the ruling should be reversed, because the order below was illegal and/or arbitrary. Well, it was illegal for basically 5 different reasons. In State versus Lane, they talk about 5 different ways, 5 different subcategories of how an order can be illegal. You can have a fundamentally illegal ruling.
So why was it fundamentally illegal?
It was fundamentally illegal because basically the judge found him guilty of something that he had not been found guilty of by a jury or via guilty plea.
Wasn't this a guilty plea?
What I'm saying is he pled guilty to something different from what the judge at the motion hearing below was finding him guilty of. And so he was charged originally with possession of over half a gram in a school zone, which would be a Class A at the time.
And he pled to a Class B.
He pled to possession under half a gram in a school zone, which would be a Class B at the time, or today it would be basically a Class C because there were no children and it was more than 500 feet from a school. But so at the time it was an A dropped down to a B, whereas here the judge ultimately denied the motion by saying that he couldn't get less than,
You said less than a B.
under today's law, the judge was basically saying that he was still guilty and had been found guilty, or was acting as though he had been found guilty of selling over half a gram, which would today be a B. But the problem with that is that's not what he pled guilty to. That's not what the parties agreed on.
Let's back up a bit. This new law gives the judge discretion whether or not he's going to resentence somebody.
It does, but not at the part that he erred on. Like once you get past the part that the judge erred on here, then you have some discretion about whether to implement the lower sentence. But first, there's step one. You're supposed to look at what the sentence would be under modern reformed law, which in most cases is lower, not always. But step one, you look at the sentence and figure out if it's lower. And then two, if it is lower, then you go to step two, and then you look at you drop the sentence down to the lower sentence unless the interests of justice would weigh against modification. So first you look at whether it's lower, and then you look at the interests of justice. Here the judge didn't even get to the interests of justice phase, although he alluded to them. He didn't get to them because he said that the new sentence would not be any lower. And the problem with that, the state has basically responded. They've tried to say, well, it's not worthy of the writ of certiorari because it was a discretionary decision, and certiorari is not applicable to those. And if that were true, if that were what the record actually showed, I would agree certiorari wouldn't really make sense, most likely. We wouldn't have a very good appeal. The problem, though, is the state has misrepresented completely what the ruling even was. Not only did the judge not get to the interests of justice part of the second step of the analysis, but when he alluded to the interests of justice, when he alluded to that step, he implied that the interests of justice weighed in favor of resentencing. He said he implied that they supported the movement. The judge said fairness. He said, basically, you're making an argument based on fairness. He said, fairness is not what this law dictates, which again implies that, if this law allowed me to be fair, I would give you relief. He also said, and so under the drug-free school zone, I can't resentence you under that, so it stays at 12 at 100. So I'm going to deny your petition. It doesn't have anything to do with whether or not I think you deserve it or not, and that's on page 15 of the sentencing of the motion transcript. And so he's saying basically he's suggesting that fairness or the interest of justice would weigh in favor of resentencing. He's suggesting that the person does deserve resentencing, but he says I can't resentence you, and that's because he's unfortunately erred on step one. And so he's not making a discretionary decision. He's making a fundamental error of law in finding him guilty of what would now be a Class B felony, even though the defendant only pled guilty to a Class C. And again, under the Sixth Amendment and under Blakely versus Washington and other authorities, that would be a fundamentally illegal ruling. Arguably, it would be, I would say, a palpable abuse of discretion. It would deny him his day in court because his day in court would have been to have a jury decide whether he's guilty of C or B.
But the thing is, though, he pled guilty. There was never a jury involved. He pled guilty to a very reduced sentence because if I remember correctly, he had a lot of drugs on him, if I remember correctly. It's like 50 grams or something like that.
I think 50 grams is the same as .5 grams. It may have a higher
50
fine.
0.5 grams, 50 grams, anything over 26 grams would have put him where it would have been a B felony with no probation. I mean, anything over 26 grams of cocaine would have put him outside of probation by statute.
Well, he
He
didn't-
pled to 0.5 grams, under 0.5 grams, no, 0.5 grams or more, which would be a B felony, and he could ask for probation.
Well, he didn't ask for
Well, I
probation. It was,
understand that,
but,
because he still was in the school zone, but I'm just saying it reduced it. He would have been he wouldn't have been A based on the drugs alone, but he would have been A in a school zone. In this way, he got reduced down to from 50 grams to less than 0.5 grams.
I mean, I was not aware of any specific bar on probation. Again, probation didn't have to do with this case, but the only difference I was aware of, I think, is over 26 grams. I think there's some kind of mandatory fine or something, but I mean, basically, they agreed to give him a 1-grade drop in exchange for his guilty plea, but they made him keep the school zone. And they still made him plead to this other gun charge, which is pretty much unrelated to this appeal right now, that was consecutive to it. And so they gave him some incentive to plead, but they didn't give him any what I would call a sweetheart deal or anything.
But we're still, whether, you know, it was a good deal or not is not really before us, because he pled some time ago. And so his voluntariness of his plea is not an issue.
Correct. Ultimately, what's at issue legally is just that he pled guilty and there was a finding of guilt that he had less than half a gram of cocaine, and you're not allowed to, the judge can't, I mean, I talked about in State versus Soller in my brief, the Tennessee Supreme Court said that a judge can't just change a plea agreement after it's been presented and accepted. And in fact, in State versus Leaf, which is one of the cases I cited about the interest of justice and transforming a wrong appeal to a writ of certiorari, that was a case where this court granted certiorari because a judge had unilaterally just changed a plea deal. And that's the same basic situation we have here, where Mr. Hardin agreed to plead guilty to less than half a gram of cocaine per a plea deal. The state also agreed to submit that as the plea deal. The judge accepted it, but then now, however many years later, the judge is mistakenly getting confused and changing it to a Class B when it should be a Class C. And so, and again, because he did that simply as a fundamental illegal act, an act outside his jurisdiction, because again, there's no jury verdict of over half a gram, there's no finding of over half a gram by a fact finder. That was an illegal act. It is worthy of the writ of certiorari. And because he did that as an illegal act and not as just a discretionary decision, that's why it's worthy of the writ of certiorari. If he had said, well, I do have the right, instead of saying I can't resentence you, if he had said, well, I could resentence you, but I'm choosing not to because I think you've been a very bad person in prison, or you've got too many other things that you've been found guilty of, I just don't think you're worthy of it, I don't think you deserve it, then we wouldn't have any leg to stand on and there wouldn't be any grounds for writ of certiorari. But he didn't do that. He said, I can't resentence you. It doesn't have anything to do with whether I think you deserve it. Fairness is not what this law dictates. And so for those reasons, the writ of certiorari is justified, and I would ask that this court grant the writ and then reverse the lower court's order. And I'll come back for rebuttal.
All right, thank you. Good morning, General.
Good morning, Your Honors. Ben Ball on behalf of the state. This court should dismiss this appeal. As the defendant concedes, there is no Rule 3 right of appeal here, and this court should not grant a writ of cert here. And when the defendant talks about the conversion of a Rule 3 into a writ, he talks about the good cause requirement, interest of justice. I want to be clear, that's talking about the decision of whether to convert the pleading into essentially an application for a writ of certiorari. Granting that writ is, the standards are higher, and the defendant cannot meet those standards here. This is not a fundamentally illegal ruling. It's not inconsistent with legal requirements. It did not deny the defendant his day in court. It's not a decision beyond the court's authority, and it's not a plain and palpable abuse of discretion. And I would submit to this court that it will be extremely rare that any of these cases involving the denial of a motion to re-sentence under the Drug-Free School Zone Act can meet the requirements for a writ of cert. I'm not saying that it can never happen, but it would be extremely rare. So I would urge the court to dismiss the appeal. But if the court looks at what the trial court did here, if the trial court did not abuse its discretion, I would submit to the court that my friend on the other side misunderstands what the trial court did here. Whether the defendant was eligible for resentencing wasn't contested. The state conceded that this was greater than the 500 feet, no vulnerable persons were present. That wasn't in contention here. So this all came down to subsection H, the interest of justice. And that's what the trial court's talking about. The trial court knows what the defendant pled to. And subsection H, it specifically talks about looking at whether this was a plea. And what he's saying is essentially, your plea, which was quite favorable, brought you down to what the sentence would have been were you sentenced for what you actually did under the old law, under the new law, I'm sorry. The court can look at that. That's why the legislature put that in there. Because there's a very different scenario than when someone is convicted by a jury and goes to a sentencing hearing under one of these Drug-Free School Zone Act cases, and when someone has received favorable treatment already through a plea and then seeks resentencing. And that's essentially what the trial court did here. And this language about deserving or what the court could or couldn't do, I read that, and I think this court can look at it and will reach the same conclusion, that this is sort of conciliatory language that the trial court's making. This is not because you're a bad person, this is because what the law says. And the law requires the court to look at the interest of justice, and here the interest of justice did not support resentencing. So I'm keenly aware that this is the last argument of the day and that I'm the only thing standing between this court and lunch and travel. But if this court, if this court has no further questions, I would ask this court first to dismiss this case. But if not, to affirm the trial court's denial of resentencing.
Talk about the trial judge's language that Mr. Justice brought up for a minute when he's saying, I can't do something, something about fairness is not involved, or I can't remember, but it sounded to me initially at least kind of like the trial judge was saying, I can't give you any further relief on this, which I mean, he could have given him further relief. Don't you agree with that? I mean, it sounds like your interpretation is what he means is what he was trying to say was, you've already gotten enough of a break here, and I can't, parentheses, in good conscience, in the interest of justice, give you any more of a break. Is that what you're saying the judge said?
Your Honor, that's how I read what the judge said. I mean, I realize that taken out of context, those comments sound like the court maybe didn't believe it had the ability to do that. That's not what's going on here. Whether the defendant was eligible for resentencing, again, was never contested by the state. Right. And I think if you look at the entire context of this, the state is saying, look, we get that he's eligible. We want you to look at the interest of justice and look at this plea. And that's what the state emphasizes in this argument, and the court goes right to that. And the language at the end about, it's essentially saying, this is not about whether you are deserving, sort of this conciliatory language, but the I can't, I think is like, as you point out, Your Honor, is sort of an in good conscience, given the plea, given the interest of justice here. And the court didn't even get into the fact that the defendant had a considerable record of disciplinary infractions going back to 2011 in his TDOC record. But yeah, Your Honor, I would submit this is just sort of general sort of conciliatory language at the end that was unnecessary, but did not reflect that the trial court misunderstood the law. I think the law was clear, the parties understood, and this was a focus on the interest of justice.
All right, thank you, General.
Thank you, Your Honors.
Mr. Justice, rebuttal?
Mr. Justice, before you get started, let me go back to what the state just mentioned, and I think what you were talking about, and I guess based on what I've read, where the judge talks about, a B felony versus an A felony. The impression I got from reading this is that what the judge was talking about is what he could have gotten had he gone to trial as charged. It would have been an A felony, and if he then came to the court and asked for relief, the judge could reduce it to a B felony under the statute, could reduce it down to a B. But he already was reduced to a B, and so at least the way it appears, and again, it wasn't that he was confused about the law, he was just talking about what he was good for versus what he got. And had he been convicted as charged, the reduction would have gotten him down to a B.
I don't think Your Honor is interpreting that correctly, because the way I thought he was reasoning was he was saying an A felony is 15 to 25, a B felony is 12 to 20.
No, it's
And-
B felony is 8 to 12.
Well, either one, 8 to 12 or 12 to 20, depending on your range. But he was saying that because he made this separate error that I didn't really focus on in this oral argument, where he basically said 12 years at 35% is not less than 12 years at 100%. And he was basically saying, since your minimum punishment, since you got 12 years, and since your minimum punishment is 12 years at 35%, and that's not less than 12 at 100%, I can't resentence you. So I think he was saying, ironically, if you had been found guilty of an A felony, and say you got 15, then I could now resentence you to 12 at 35. And so I think that was the way I interpreted it, was he was confused about that separate error of saying 35% is not less than 100. He was basically just saying it's just the term of years that matters and not the probation, eligibility, good time, program time. And so that's the way I read it. But, ultimately, the state is basically arguing that that the judge was just distorting his own ruling, that he's basically that he's saying, I'm not denying you because you're a bad person, but really I am denying you a bad person. And the state calls it conciliatory language. I mean, really that would just be lying. It'd be the judge saying, well, I'm not really denying you for this reason, but really I am. And that's not how I interpret it, and I don't think that's correct. The state's saying, well, I denied you saying it's not about the interest of justice, in essence, but really it was about the interest of justice. And I just submit the state's misreading that, and a plain reading of what the judge actually said is that he was denying it because the sentence could not be lower, it could not be a lower term of years, and that the interest of justice, whether the inmate deserved it or not, had nothing to do with it. And so, the state, another way of sort of viewing their argument is they're basically saying the judge could have, if he had wanted to, ruled against him on the interest of justice. But again, a plain reading of what the judge said and his reasoning is that he just did not do so. And quite the contrary, the judge's statements, I've already quoted them, and I attached a copy of his whole ruling to my reply brief, but I mean, he implied that he would grant him relief if he thought he had the authority to do it. And so I just submit that we have met the burden for the standard for a writ of certiorari. The state has said we cannot meet that standard. But if you've got a judge that's basically misclassifying the inmate denied him on the basis that he's guilty of a crime for which he was never found guilty, to which he never pled guilty. If you've got the judge also, as I've talked about, getting confused about whether 12 at 35 is less as a matter of law than 12 at 100. These are legal errors. They are fundamentally illegal rulings. It's a palpable abuse of discretion to make these rulings, and so therefore the writ of certiorari is justified. But obviously, Your Honors can pore over the ruling a little more carefully and decide for yourselves whether I'm right and how I'm interpreting it. If there aren't any more questions, I ask that you issue the writ of certiorari and then reverse the order.
All right, thank you, Mr. Justice and General. Appreciate the arguments and briefs. We'll take it under advisement. Is that all our cases then?
Yes, Your Honor.
All right, I do want to thank our state trooper out here for looking after us the last couple of days. We really appreciate it. And the clerk's office as well for helping us get these cases disposed of and making us look probably better than we deserve to look. So thank you very much. All right, we're in recess or adjourned until the April session.
Yes, sir.
I don't know the exact date on that, but so it's somewhere late in April.
All rise. This court stands adjourned until April of 2024.